Good afternoon. Look at this, everybody. Short sleeves. Spring is here. I just had the most amazing lunch. I sat outside on my deck and it was hot, not hot, sweaty hot, but warm, like warm. And I just feel so amazing. I love the heat. This California girl loves heat. It was hard to come in, but I was excited to come in because we're going to talk about something that's really important today. Thank you for being here watching. Um, when somebody dies, it's very difficult for so many reasons. Number one, for most people, it's losing somebody that we love. I realize that sometimes death comes as a relief to some people based on their relationship, but I would say for most of us, with death comes, you know, remorse, grief, guilt, sadness, anger, anxiety, depression, and we have a lot of reactions. And on top of all of those emotional things that we're trying to manage, there's the actual logistics of death. What do we do now that somebody is no longer around? What do we do with their home, their property, their finances, everything down to, their stapler in their house? I'm looking at a stapler on my desk. What do we do with all of these things? And I know that for me, when my dad died, he died suddenly of a massive heart attack with nothing in place, no will, no nothing. So I experienced this firsthand, what the stress is of, not knowing what to do with all of these things and not even having instructions from my father as to what we should do. So today we're going to be talking with notary Liat Lev Ary. I'm not saying your name right. Say it right. I did. Okay, I said it right. Liat. She was an attorney for many, many years, and now she works as a notary. And here in the province of Quebec, just so everybody knows, notaries they actually go to law school. It's not the same as a notary public in the States, which are more witnesses to the signing of documents. This is an actual legal education, and many notaries have already practiced even as attorneys. So that's who I have on board today, is a real legal authority and a colleague of mine, Liat. Thank you for being here.
Thank you for having me. It's very nice to be here on this spring day. I'm wearing long sleeve because I had to go to court online, so I had to be presentable.
Okay. Well, I changed my shirt. I was wearing like a tank top. I dressed up for our interview with a short sleeve. um, Liat, there's so much stuff we can talk about, what to do after somebody dies. But the first thing I want to ask you is, what is the biggest surprise that people have after somebody dies and they come to you about the management of assets and such? What's the biggest surprise that people come to you with that they weren't aware as to what would happen after somebody dies?
So I have a few, but the most important one, in my opinion, let's say they know there is a will. In Quebec, there's a different process, and maybe we'll touch upon it later. But if there is a will, they think that they go to the bank, they take all the money, and they distribute right away the next day to the beneficiaries. But this, when I tell them, no, 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 it could take up to 2 years before you can really distribute all the money. And I explain to them why, and they're like, what? No, 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 it's 1, 2, 3, and this is done. And I'm like, no, it really isn't. And if you do it like that, there could be repercussion, legal, fiscal, financial, anything else could come rain on you, and you will not be prepared. So they're very, very overwhelmed, in addition to the grief and the sadness and the remorse, to be able to think that now they have to do everything by the book and follow guidelines and follow rules and do everything the right way, so they won't end up getting penalized in many ways.
So you talked about if they have a will, and I just took a note. I want to go about if someone doesn't have a will. So we will get to that. But let me just ask you something. It, is the delay because of like notifications that you have to do? Because I know when my grandfather died, I was named in his will. All of the grandkids received something. And at some point, I got a letter from my uncle, who was the executor, notifying me of something or other. So is that why? Is it because all of the beneficiaries or living heirs have to be notified? Is that why all of the delays?
So it really depends on what kind of situation we deal with. If we're talking about the situation where there is a will, then just the beneficiaries themselves have to be informed. But in addition to beneficiaries, there's also particular legatees. So let's say if I want to leave in my will to you, Stephanie, $10,000, but everything else to my children, you're a legatee, you're not a beneficiary of my will, so your portion comes off first. I do not have to notify you of everything else that goes around in the will. I just have to give you accounts on your portion and when it is you need to get it. But there are different delays, legal, fiscal, that you can distribute the money. And as long as you didn't distribute the money, the liquidator is responsible for the money and for anything that has to do with the estate. So, for example, if the estate owes money to the fiscal authorities, so it could be the estate of the person or the person themselves before they died.
Okay,
And the
so wait,
liquid,
let me stop you there because you're going very fast. So if the
oh, sorry.
person, the deceased person has debt is what you're saying, then the first obligation is to pay back that debt before the liquidation of assets.
Absolutely. That's the
Okay.
first thing. So the year after the person died, let's say somebody passed away in 2020, now they will have to file taxes until the date of the death. But the following year, the estate will have to follow taxes, especially if you have GICs, investments, money that's continuing to produce revenues. The estate will have to declare those revenues and pay them. Now, let's say the deceased did not file taxes for the past few years or even the last year. The estate did not file taxes. The executor, that we call in Quebec liquidator, is personally responsible for those. And if, let's say, I gave you, Stephanie, the $10,000 that somebody left you in your will, and the debt that the deceased owed is $100,000, you got your money, you spent it, but the liquidator is responsible personally from their own pocket to make up the money that they owe the person or the estate owes the revenue authorities, which is why we
Wow.
don't go it so fast. We have to make sure there's no debt.
So the person who was named the executor slash liquidator, depending on where you are in the world, and I'm sure there's other terms in other places, they're personally responsible. So in other words, if my dad, when he died, owed $50,000, he named me in a will, which he didn't have, but hypothetically, let's say he had, he named me, but he doesn't have enough money to actually pay back that debt. I'm responsible to pay the debt, or I'm just responsible to file the taxes for the debt.
If the estate is solvent, you, as the liquidator executor, are responsible to pay first and foremost any debt the person had. So it starts with testamentary, funeral expenses, credit card, mortgage loan, car payments, whatever there is, including taxes. Taxes to the city, taxes to the government, whatever there is. And then once everything is paid off, you calculate what's left. If there's enough debt, if there's enough assets to cover the bequest that we made particular legatees, we start with those, and then we go to the bulk of the estate, which is your beneficiaries, your children, your spouse, your partner, your cousins, whatever you name in your will, if there is a will. If no, then the law decides who are your beneficiaries.
So, but when you say that I'm responsible to do that, again, hypothetically, is it me in my pocket, my own personal finances, or I'm responsible, let's say, from my father's assets to cover everything? And if he doesn't have assets, I'm not now financially responsible just because I'm his daughter, right?
You could be held responsible not because you're his daughter, but because you're the liquidator. So even if his assets did not have enough to cover the debts, there are procedures to follow to renounce the estate, to renounce the office of the liquidator, so you yourself will not be held liable. In such situations, the government takes over and they try to see if they can finalize everything and pay all the debts. And if there's anything left, most likely they will call the family and they will say, listen, we settled everything. Now there's like $200 left. Do you want to claim it or are we moving on?
Wow.
So
Okay.
it's
So I would think that a lot of people, I mean, I don't want to be a liquidator now. Like
right.
this
And
sounds like awful if I would have to be responsible. So a lot of people, this must be one of those surprises I asked
they
you
don't know.
about. They don't
Yes,
know. And so all of a sudden they're like, okay, my dad died. He named me. I go. And now I find out I have to cover all of this debt. Forget it. I'm going to renounce. I'm going to resign from this position because I don't want to be responsible anymore.
absolutely. So it's one of the surprises. But you then again you have those situations where you know that your relative didn't have much to begin with, and you know that there is this credit card debt or a loan that they took or a car payment that they took, and you are not going to be able to afford it, and you know that their bank account was close to zero, or even if it was a little bit more, not sufficient to cover everything else. So they call me and they tell me, what do I do now? And I said, listen, if the estate is deficitary, we have to calculate. But if it's in deficit, it's better for you to renounce. Otherwise, you will be held responsible personally. So it's not good for you. And then they start understanding that maybe it is better to renounce. and resign as the liquidator, or renounce the office of the liquidator if they didn't start, because at the end of the day, they won't get anything, but they won't be liable for anything either.
Yeah, so I do want to get to if someone doesn't have a will. I haven't forgot that. But just on the same thread that we're on, I'm just wondering as you're saying this, the emotional part of this for a family member who, for example, if my mom or my dad names me in their will to do this for them, and then I have to resign just because of my own, what I don't want to take on all of that financial responsibility and have to use my own money to pay debt. But it must be very hard emotionally because you were named and someone trusted you to do something. And now you're saying, no, I'm not going to do the job that you entrusted me to do. There must be a lot of hesitation and emotional reaction for people having to say no.
There is, but then again, I see so many wills that are old, and people were in a much better financial situation when they left the will, but they did not review the wills over the years or revoke them if something was to happen. So I have this woman who was very, very wealthy. She had a very big transport company. And when she had the will, she left everything to her spouse and her granddaughter. And when she died, 15 years later from cancer, wasn't a big surprise that she's going to die, but she didn't do anything all those years. She did not adopt her will. And she was basically a pauper. All she had was a car with loans on it. And her spouse called me, I don't know what to do. I don't know what to do. They're knocking on my door. What am I going to do? I told her, listen, you must renounce as a beneficiary. Your granddaughter must renounce as a beneficiary and as a liquidator, both of you, because otherwise they're coming after you personally, and you don't have the money to pay and you don't want to pay it. So there's that ambivalence. On the one hand, you were in charge to do something, but on the other hand, this is not what you were signing up for. This is not
Yeah.
what your relative wanted you to do. They wanted you to benefit from the money. They didn't want you to sink deeper with their debts.
Yeah, that's such a great point. And this is something that I say to people when their loved one is no longer apt and they feel so bad about, moving forward with a legal procedure to say, my loved one can't manage things anymore. But I talk about how, but this is what your loved one asked you to do in their document. So it's the intention behind it. So what you're saying is the intention behind the will is not to burden the beneficiaries with debt, so that you have to almost be a psychologist and like go to that other layer of, no, that wasn't the intention, and it's okay for you to step back. But I suppose before you step back, you have to get all of those finances in order to make sure that there's the full informed decision of, no, there is nothing left, it really is the right thing to do.
Exactly. And the law is different everywhere, but in Quebec, the law allows the beneficiaries 6 months to renounce the estate.
Okay.
There's one more month of grace. So the timeline starts from the moment of death. And I've had cases where somebody called me and they said, listen, I've been estranged from my father for 40 years. And I just found out that he passed away 4 months ago. And I have 2 more months to renounce because I don't know anything about him and I don't want to be stuck if there's any debt. What do I do next? So you have really 6 months of the date of the death and not the date that you found out that the person died. And you really have to act upon it. And this has to be done before notary in Quebec because we have to register it so everybody can know that you renounce and that officially they don't have to come to you because you're not the right address to go to.
Yeah, and for people who are watching who are not in Quebec, basically the bottom line here is get yourself informed before you do anything. Make sure you figure out who that legal authority is in whatever state you live in, or province or country, so that you can ensure that you're not, making an ill-informed decision that's going to come back and bite you in the butt, I guess is. So now, what happens if people don't have a will? I mean, I realize that the laws of Quebec are one way versus in other areas, but just tell me, how is it done here? And then again, this will give people the prompt to, in their own state or province, to
Right.
look into the process. But what is it like here?
So here in Quebec, if a person dies without a will, the law determines who will be the beneficiaries and in what proportion. So for example, I'll give you a few cases. If we're married and we pass away and we have children, doesn't matter how many children, doesn't matter how old the children, the spouse, and when I say spouse, it's really legally married, not civilly united, not living together, not common law, what people call here and outside of Quebec. You have to be legally married with a marriage license and a marriage document. Uh, if you die, you have a spouse and you have children. in Quebec, your spouse receives, if you don't have a will, 1/3 of your assets, and your children share between them 2/3. If you have children but no spouse, let's say you're divorced, you're a widow, widower, the children get everything in equal share between them. If you don't have children and you have a spouse, your spouse gets 2/3, and your parents or grandparents or siblings or nephews share the other 2/3. So you find yourself in a situation where you're here and you share with the parents, the siblings, the nieces and nephews, down, and it's like becoming very convoluted. Now, it's very difficult to proceed, not impossible, but difficult, more challenging, because A, you need to identify all those people. There has to be a declaration produced here in Quebec before a notary of who died and who are legally their beneficiaries, entitled to inherit them. And then, in addition to everything else, there has to be a nomination of a liquidator or an executor by the heirs. The majority of heirs must name the liquidator. Now, not all the time people will agree. Let's say if I'm the spouse and I have to inherit with my parents-in-law or my grandparents-in-law, we don't get along. They don't want me to be the liquidator. I don't want them to be the liquidator. It's a mess, and sometimes it results in going to court and having the court decide who the person will be. So that causes further delays and, of course, more expenses for the estate. Sometimes you find yourself in a situation where you have minor children, and here in Quebec, minority is 18. Some places in Canada it's 19, and most places in the USA it's 21. So if you're beneficiary with minor children, they cannot name the liquidator. Let's say you're the other parent. One parent passed away and you are the other parent. It's very difficult to name yourself as the executor. And what we do often, we have to go to court to avoid a context where somebody will say, well, of course you wanted to be the liquidator. It's normal that you would, but there's a conflict of interest for you, Liat, to come and say you want to be the liquidator, and you're naming yourself as the liquidator on behalf of your minor children, because there's a conflict of interest there. So the court has to clarify and make everything transparent. So again, we're saying court expenses, court time, delays, and procedures that you have to follow.
Wow, it can be very complicated, all as you're grieving. Like,
Yes.
I mean, my God. And it's like it sounds like there's so many different directions things can go, and so many different tasks that have to happen. And one thing that you brought up was the issue of family dynamics, which we've worked together on many files, and we're both in the same, I mean, you're a lawyer, I'm a social worker, but in the litigious area of practice. And I mean, family conflict, it's incredible. I mean, I don't know what the percentage of files that I have where people don't get along, but it's not like it's only 1%. I mean, there are a lot of families that are not getting along. I mean, the court, though, and the law, it must protect from that, right? So even if someone mistrusts the liquidator or thinks they're going to do this or do that, or I'm not getting my portion, I mean, the laws are pretty clear. It's not like a liquidator can steal money, right?
Well, no, they shouldn't, but there are certain procedures that the liquidator has to follow. So they have to render accounts to all the beneficiaries upon demand. And if they don't do that, or if they don't act in the best interest of the estate or the best interest of forwarding the estate, you can go to court and ask to destitute them, to remove them from the position. But again, this all takes time, effort, energy. And in some situations, I have a case right now that I'm working on, but I had a similar case a few years ago. What happened is the man had a notarial will, which here in Quebec is the best will we can have. And he was married at the time. He did not have children. And he said, if I die, everything goes to my wife. If my wife is not alive, everything goes to her sister. She gets, my cousin gets 10%. My father and my stepmother get 40%. And the sister-in-law, the wife's sister, gets 50%. He got divorced, never had children, never changed his will, dies. What happens now? I meet his liquidator very by coincidence. He came to see a lawyer in my office, and he said, oh, you are the notary? Can I ask you something? I went to see one notary, and one notary said, because she died, we go to the second order, which is the stepfather, the father, the stepmother, the father, me, the cousin, and the sister-in-law. But another notary said, no, because he died, but the wife, was divorced from him. She's not entitled by law to inherit anything from him. So who gets it? It's like he doesn't have a will. So he said, so I didn't know what to do. I called your professional order and they told me find a third notary, and whatever they say, they can either go one way or the other. Whatever they say, follow that. And I said, listen, I'm more inclined with the possibility that because of the bad drafting and because of the fact he was divorced and never changed it, it's like he never had a will, because legally she's not entitled. And it doesn't say that if she's not my wife or if I'm divorced or whatever, I still want my sister-in-law to get it. So what happened is then I found out that the father and the stepmother were alive, but he had a birth mother that abandoned him when he was 8 years old in Italy, and the father went to pick him up, and he's never seen her since. She's entitled, like we said before, if I don't have
Oh my
any
God.
will, the mother, the biological mother, and the father are entitled 50-50 to split his assets. And it would have been a great travesty of justice to give this woman who abandoned him when he was 8, and she was here in Canada a few times, never made a contact. He died before her because he was sick. She never reached out to him. I couldn't see myself saying, let's give this mother, let's find her and tell her, listen, your son died, let's give you 50%. And funny enough, I have another case very similar right now where one of the parents lives in South America somewhere, and I have to locate him and tell him, your child died and you're legally responsible for 50% of the estate, but I understand from family members that you don't want anything to do with it because you basically abandoned them. So you see all those things can
Yeah.
come, and they are like you build upon grief and all more things that you didn't even expect.
And do you, as a notary or in your law school training, because you're talking about really complex family situations where there's, of course, and I know, and I'm sure you will confirm, the more money, the more problems. And boy, do I see this. My husband and I are convinced we need to spend every single dollar. So when we die, there's nothing for our children to argue about because like it just causes so much havoc in families.
My
In
mom
your
says, I'm taking everything with me, don't worry.
exactly.
Yeah,
Exactly. I'm doing you a favor. I'm going to spend all my money.
yeah.
In your training, in your legal training, are there, courses on how to like deal with these family dynamics, set boundaries, manage all these emotional things? Because what you're describing to me is like a combination of lawyer, social worker, having to manage all of these emotions. And I'm sure there's many explosions and lots of anger. Are you guys given any training along those
No,
lines?
no, sadly, no. The training that we get is very basic and dry. We do, however, read case law, and we learn things about case law we hear from other colleagues. And more often than not, we need help from external sources like mediators, like family mediators, like people that will come from the outside. For example, if anything becomes litigious to the point that they're arguing, I have to step back. I have to be impartial, and I cannot help people who fight. I can help you settle and smooth bumpers, but I cannot tell you, you have to do this and you must not do that. I cannot do that. I have to withdraw. And then the fights really start where you have to hire attorneys. Each side has to hire their attorney, and the bill goes up. The time goes to waste, and a lot of the time, a lot of money goes to waste when you do that. When two attorneys start and both sides are not willing to relent or to compromise somewhere, it's very difficult and very charging.
Yeah, I'm in that situation all the time, Liat, and I know that as a notary, and again, for anyone who's just joining, notaries here in Quebec actually go to law school. Liat practice as a lawyer. It's not notary public. They're a legal professional here. And I know in my line of work, because I'm in this litigious area of social work, that the same thing happens is that when these two sides are fighting, it's just more money that's going out the door and everyone's fighting about all the money. And by the time the fights are over, there's no money left anyway. And I feel as a social worker, I can't say that I'm a mediator, but I do feel like I'm mediating in a lot of situations is before I finish that report, naming who's going to be in charge of that money is to try and find a solution in which everybody is happy to prevent going to trial and all that long drawn out court process. I mean, are you able to do that, or do you find that, or
Yeah.
is your role as soon as there's conflict? I mean, immediate. I know you said a few bumpers you can do, but like, how do you determine when? Look, there's no way we're going to do this smoothly. Unfortunately, you guys are going to court. Like, how do you balance that?
So luckily, I bring with me all my years of experience being in litigious world, and I know when things are heating up. So I did help. I'm not a mediator either, and I keep telling my clients I'm not qualified to be a mediator. But with my life experience, I can help you see if what you're saying is really something small that we can find a compromise and overlook it, and look at the big picture, which is what I like to do. To look at the big picture. What's the bottom line? Do you want to have money, or do you want to keep dragging it at court for 10 years or 5 years and waste all the money on lawyers and legal fees and court fees, like you said, and then get to nowhere at the end of the day? Nobody will be the winner. And not only you won't get the money, it's really draining. I'm talking to you like an ex-lawyer. It's draining to go to court. It's draining to go through the drama, to get prepared, to testify, to have this. It's like a burden on your head, on your shoulders, on your heart that you don't want. So I try to explain to them that very rationally and very legally. A lot of them listen to me. I managed to make peace between many family members who haven't spoken in years, and I managed to make peace so they can go ahead and finish with the succession and estates of their parents, that they have not spoken to the parents, to the siblings, whatever. I manage. Some cases I tell them, listen, I see, even with all the efforts that we've put, that I cannot be of service anymore. I feel like we're not getting anywhere, and it's not going to be resolved amicably. And this is where I tell you that I have to withdraw and you have to go your own separate ways. Each of you have to hire legal counsel, lawyers, and you have to meet on the battlefield. Hopefully they can compromise. Many courts offer today mediation services, but everything takes time. Everything takes time.
And of course, that's more money too. Although the cost of hiring a mediator for 10 hours certainly outweighs having to go to court for a 4-day trial, right?
Yeah.
So it's kind of
Yes.
worth spending that time. Um, what do you recommend then that people, if they are going to do a will, what kinds of things are essential? Should you put things in that will that talk about if there's family conflict, and I'm setting aside this amount of money for a mediator, like some of these things to help smooth that process over should tempers flare, because we can think that our kids are going to get along and everything's going to be fine, but that's not always the case. Can
Right.
you add these kind of special clauses and such?
Yes. So first of all, I would start by I always suggest to my clients to name at least three liquidators, executors in order. So if one cannot do it, then we go to the second and to the third. So that way you don't find a void or a gray area where nobody's named by you. Secondly, there's always the option of going to arbitration or mediation, which is a preferred way in a notarial will, because you could go to court, but if you try a mediator or an arbitrator, it's going to be much faster. Mediator, you can challenge their decision and maybe appeal it, but arbitrator's decision is usually final and you cannot appeal it. All the money is borne by the estate, so those are costs that are going to be issued by the estate. But also what I say in different situations, if I know ahead of time, and some clients tell me, my kids do not get along, what do I do? Then I tell them, it's good that you told me right now, because I would not have any way of knowing. I don't know the family dynamics if those are not people that I know personally. Let's add here a clause that if your children disagree on anything, they should go to a third person that you choose right now. And whatever that third person say, that's it. It's a final decision. And if that person is not available for any reason, let's say it's traveling, or God forbid they died also or became incapable, then I also put a provision that the children or the liquidators will name together somebody that they agree upon, and I time it within 21 days, within 14 days. And then by the time they have to put the grievance in writing, go to that person, whatever that decision they make is the final choice. So I try to eliminate the process of going to court. Sometimes it works, and other times you see that it's just repeating the same thing over and over until you're blue in the face, and there's
Yeah.
no choice but going to court. But we try.
Oops, sorry. Yeah, sorry. I thought we got a comment of it. Yeah. So really, also what I'm hearing you say, Liat, is you really need to try and find someone who's an expert in this area. And I'm so glad to be talking to you and just highlighting how incredibly knowledgeable you are in this area. And
Thank you.
it's the same thing when people call me and say, "Hi, I heard you're a social worker. I'm having trouble with can you help us out?" Just because I'm a social worker, skilled in helping manage behavioral challenges in the home of someone on the spectrum, right? A capacity evaluation I could do for that, but not a management of behaviors. So I think it's important that we find professionals who are knowledgeable in their area, and just because it says lawyer, notary, social worker, that we don't assume that they have that specialty. What are some questions that people can ask to find? Obviously, I would want them to find you here in the Montreal or Quebec area for sure. If you're outside of Quebec, what's some advice you can give people of how to find someone who really has that detailed knowledge like you do?
So you really have to look at what the person does, whether it's a lawyer or a notary, and what their specialties are. So, for example, in Quebec, many notaries do real estate transaction. I also do that, but this is a small side of my practice. I mostly do putting people under protective supervision, like the files we do together, liquidation of estates. Where I either accompany the liquidator, the executor, and I help them, guide them. So what's next? Or I'm named in the will as a professional liquidator because the family member that did the will, the father, the mother, wanted to spare their kids the hassle of going through that procedure while they're grieving, and they knew it was a hassle because they have done their spouses, their mothers, their fathers, so they preferred paying for a professional like me to do that, so their kids will be at home, relax, and then I come with them. Now do this, now do that. Here's your check, goodbye, and that's it. It's finished. So you really have to look at their CV, if they have a website, if they have a LinkedIn profile, their areas of expertise will come across there, and you can see what people, if they have comments or reviews, what people write that they did with them. So, for example, if you go on my site, you will see some people said we bought a house. Some people said she accompanied us through the estate liquidation of my parent. Some people will say it's really important to get this information, and don't be shy to ask, because the example I told you before with the guy who died and his mother in Italy would have been his property, his 50% beneficiary. That was a notarial will that is done, but the drafting was so bad that the liquidator had to go to two notaries before they came to me, and I was the one who was supposed to decide because bad drafting. A notary did it. I don't know which one. I'm not going to speak badly about anybody, but there is a notarial will and there is a notarial will. There's a lawyer's will and there's a lawyer's will. You really have to know who does it. If somebody just does it just to do it and charge the money and goodbye, it's not necessarily the best service that you can do. If somebody is going to do it because they have knowledge, then that's the best option.
Yeah, no, that's great. And before we finish off, and I'll get you to say your website or phone number, and I'll put in the thread in the comments section a link to your website as well. Just tell me, Liat, this is a bit more personal, but tell me what it is that you love about what you do, because you're in an area of practice that is difficult. It's stressful. It's not, yay, we're selling a home. Yes, there's stress, but yay, we just sold our home, or yay, we're moving and buying a house. This is a stressful area of practice. Why do you do it? What do you love?
I really love, so I do less real estate transactions because I like the personal interaction more with people, with their families, with the way that I know that when they leave my office, it's not just sign here and goodbye. I follow up with my clients. I send them all every now and again. I send them an email just to make sure that I can help them. How are they doing? How are their kids doing? How are their parents doing? I don't have any gain from it. I just want to make sure that everything is okay. And this is what I like about it, and what I enjoy doing. So when I can reach when I can reach an agreement, or when I can help somebody resolve an issue, then that's what I like.
Yeah. Oh, it's wonderful. I Liat just went on.
It's,
I see you go on
I'm
mute.
sorry. I'm sorry. I have a call. It's okay.
That's
Sorry.
okay. Are you okay? All right. So I
Yes.
just wanted to say, someone just posted a comment. I wanted to read it to you. They said, a very important and sensitive topic that should be addressed before things get heated with family members. Yes, prepare, prepare, prepare. And actually, my book says plan. Wait, there we go. Plan for aging well. Whoops. We have to plan. We have to think in advance. I mean, ideally, yes, if it were a perfect world, everybody would get along and it would be, roses and sunshine, but that's not how it always works. And when you take in the emotional aspect of death, or illness, if someone's alive and needs help, things can get really heated. And when it comes to money, things really can spin out of control. I
Right.
feel very grateful that my sister and I were very aligned when my father died without a will. He had really no assets. He had a little bit of money that we were able to divide in the end. My sister and I were able to handle it extremely well. We each know each other's strengths. We decided what we were each going to do, and it was a smooth process. And we allowed each other moments to grieve when we had to before we picked up like the execution again. I feel very grateful, but I know that's not always possible. So plan, plan, plan. Please make that will. And Liat, how do people get a hold of you if they want more information about the services you provide?
So they can either call me, my number is 514-852-5707, or they can email me. My address is notaire in French, Notaire, at Judicia, that's my company, Jud like Dan, ICIA.ca. You can also follow me on Facebook. I have a professional page, Liat Lev Ary Notary. All of my information is there. I try to write at least once a week a post that's related to either a news article or a situation that I'm living with one of my clients, or something that I read, or something interesting that I can relate to you of how important it is to do will, to do a mandate, to follow up, and to do different things the right way, because otherwise we found that later may not be too late, but it's going to be more costly, and you're going to be pennies wise and pound foolish, and you want to save yourself from this hustle.
Absolutely. And you're tagged on the Facebook page. Your
Yes.
professional page is tagged and also on LinkedIn, but I will also put your website in the comments. Thank you, Liat, so
Thank you.
much. I really appreciate it. Hang on. I'm going to end the broadcast, but hang on. Everybody get out there and enjoy that sun. Spring is going to be
Yes.
over in a second.
Yes.
We have two seasons, winter and summer. We're now in that weak, sweet zone of spring. So enjoy it quickly. And then pretty soon summer's over and it's winter. So thank you, everybody. And
Thank
Liat,
you.
hang on. Okay, hang
Yes.
on.
Yes.